Good afternoon. Welcome to this live broadcast of the Senate sitting afternoon session. This broadcast is brought to you by the Parliamentary Broadcasting Unit in partnership with the Kenya Broadcasting Corporation. The order paper this afternoon of the 11th November 2021 is quite heavy. There are a number of bills that will be read for the second time. There are also a number of bills that will require the House to proceed on a committee of the whole. There are also a few motions that would require the attention of the members of the Senate this afternoon. About 7 motions will be discussed this afternoon. The Heritage and Museums Bill, Senate Bill number 2022 of 2021 by Dr. Alice Milgo, will be read for the second time. This will be a resumption of debate interrupted on Tuesday, 2nd November 2021. There will be division. The County Oversight and Accountability Bill, Senate Bills number 17 of 2021. This is by Honorable Senator Ledama Olekina, will also be read for the second time this afternoon. It will be a resumption of debate interrupted on Tuesday, 2nd November 2021. Just a look at this bill that touches on county oversight and accountability is that the bill seeks to provide a framework for effective oversight over the county government by the Senate. The bill goes ahead to say that the Constitution of Kenya 2010 created a bicameral parliament to replace the existing unicameral parliament. This is accordingly, the Senate was tasked with oversight over national revenue allocated to the county governments. Moreover, under the constitutional concept of devolution and the principles of public finance, the input of the public is required in all executive decisions-making process. Therefore, the bill proposes to provide a mechanism on how oversight over the county budgets can be carried out. The bill also gives effect to the constitutional provisions on oversight, public participation, and participatory democracy as enunciated in Articles 96, 174, and 201 of the Constitution, respectively. The bill also provides for preliminary matters, including the short title objects of the Act, and again, guiding principles that guide senatorial oversight. The bill also designates the roles of the responsible bodies and officers in the oversight and public participation. The Intergovernmental Relations Amendment Bill, Senate Bills number 37 of 2021. This one is by the Chairperson Standing Committee on Devolution and Intergovernmental Relations, is also set to be read for the second time this afternoon. This is a resumption of debate that was interrupted on Thursday, 4th November 2021. A look at some of the bills that will see the members of the Senate proceed on a committee of the whole is the Cooperative Society Amendment Bill, Senate Bills number 11 of 2020. This one is by Agnes Zani. We also have the County Vocational Education and Training Bill, Senate Bill number 6 of 2021. This is by the Chairperson Standing Committee on Education. The Prompt Payment Bill will also go on a committee of the whole House by the Senate. At the entrance of the Senate chambers, the Speaker of the Senate, Honorable Kenneth Lusaka, has just stepped into the chambers. He will be overseeing this afternoon session. I will now hand you over to the live broadcast brought to you by PBU in cooperation with Kenya
Let us pray.
Corporation.
Almighty God, we beseech you to behold with your abundant favor and blessings as your servants whom you have been pleased to call to leadership positions in this republic. We seek guidance to treat and consider all matters that shall come under our deliberation in so just and faithful a manner as to advance the peace, prosperity, and welfare of our country and of those whose interests you have committed to our charge. Amen.
Order number 1, administration of oath. Order number 2, communication from the chair.
Order, take your seat. Honorable Senators, I have a communication. On the 7th and final annual devolution conference, Honorable Senators, as you may recall, on the 7th annual devolution conference had been scheduled to take place from 23rd to 26th August 2021 in Wote, Makueni County. The conference was postponed following a presidential directive issued on 18th August 2021 via the public order number 5 of 2021, suspending all public gatherings and in-person meetings as a measure to mitigate against the spread of the pandemic. Following consultations between the National Executive, the Council of Governors, the Senate, and other devolution players, the Devolution Conference Steering Committee at its meeting held on 18th October 2021 resolved that the 7th Annual Devolution Conference be held from 23rd to 26th November 2021 at Makueni Boys High School in Wote, Makueni County. Honorable Senators, the theme of the conference is multi-level governance of climate action, and the sub-theme is subnational mobilization in unlocking the full potential of climate action. A number of senators have been identified to represent the Senate in the conference program as either session chairs or panelists, and correspondences to this effect has been made in writing. I urge the identified senators to cooperate with the steering committee and to closely work with the Secretariat to ensure the effective participation of the Senate. Honorable Senators, the Senate on Wednesday, 10th November 2021, resolved to alter its calendar for Part 6 of the 5th session in order to allow the Senate to participate in the event. Senators may give their confirmation by signing a register to be circulated from today until Thursday, 18th November 2021. I urge all the honorable senators to save these days and plan to participate in this important event in our devolution calendar. I thank you. Next order.
Order number 3, messages. Order number 4, petitions. Order number 5, papers.
Thank you, Speaker. Mr. Speaker, I beg to lay the following papers on the table of the Senate today, 11th November 2021. 1. Report of the Auditor General on the Cagiado County Assembly Car Loan and Mortgage Fund for the year ended 30th of June 2019. 2. Report of the Auditor General on the Turkana County Education and Skills Development Fund for the year ended 30th June 2019. 3. Report of the Auditor General on the Turkana County Biashara Fund for the year ended 30th of June 2019. 4. Report of the Auditor General on the Turkana County Assembly Staff Car Loan and Mortgage Fund for the year ended 30th of June 2019. 5. Report of the Auditor General on the Vihiga County Trade and Enterprise Fund for the 6 months ended 30th of June 2019. 6. Report of the Auditor General on the Kericho County Emergency Fund for the year ended 30th of June 2019. 7. Report of the Auditor General on the Elgeyo Marakwet County Car and Mortgage Revolving Fund for the year ended 30th of June 2019. 8. Report of the Auditor General on the Elgeyo Marakwet County Executive Education Fund for the year ended 30th of June 2019. 9. Report of the Auditor General on the Kapsabet Nandi Water and Sanitation Company Limited for the year ended 30th of June 2019. 10. Report of the Auditor General on the Nandi County Assembly Car Loan and Mortgage Scheme Fund for the year ended 30th of June 2019. Last but not least, report of the Auditor General on the Uasin Gishu County Alcoholic Drinks Control Fund for the year ended 30th of June 2019. Thank you, Speaker.
Next order.
Order number 6, notices of motion. Order number 7, statements.
Statements, let's start with Senator Beatrice Kwamboka. Senator Kwamboka missing, Senator Omanga missing. So those statements are away. They are deferred. So the next statement is from the Majority Leader.
Mr. Speaker, sir, pursuant to Standing Order 52-1, I hereby present to the Senate business of the House for the week commencing Tuesday, 16th November 2021. Mr. Speaker, on Tuesday, 16th November 2021, the Senate Business Committee will consider and approve business for Tuesday, 16th November 2021, which is projected to also contain business that will not be concluded in today's order paper. The Senate Business Committee will further consider bills at the second reading and committee of the whole stages, as well as motions as contained in the program of Senate business. On Wednesday, 17th November 2021, the Senate will continue with the business that will not be concluded on Tuesday, 16th November 2021, and any other business scheduled by the Senate Business Committee, while on Thursday, 18th November 2021, the Senate will continue with business that will not be concluded on Tuesday, 16th, and on Wednesday, 17th November 2021, and any other business that is scheduled by the Senate Business Committee. Speaker, sir, with respect to the status of the legislative business before the Senate, there are 10 bills at the committee of the whole stage, 22 bills at the second reading stage, 3 of which are pending division as indicated in today's order paper at orders 8, 9, and 10, respectively. Additionally, there are 23 bills undergoing the concurrence process pursuant to Article 110(3) of the Constitution and will be introduced in the Senate upon completion of the process. Other business before the Senate includes 15 motions, 51 petitions, and statements pursuant to Standing Orders 47 and 48. Speaker. Speaker, the fifth session is fast coming to an end. However, there are key matters relating to finance which require to be dealt with. As per National Treasury Circular number 8 of 2021, the timelines for processing of the budget for financial year 2022-23 will be altered in view of the upcoming general elections. As such, the budget policy statement, the draft division of revenue bill, and the draft county annual revenue bill for the next financial year are projected to be submitted to Parliament by 30th November. I'll read that again, Speaker. As such, the budget policy statement, the draft division of revenue bill, and the draft county annual of revenue bill for the next financial year are projected to be submitted to Parliament by 30th November 2021 for consideration and approval. This will certainly affect the schedule of Senate business. For this reason, the Senate Business Committee will meet and give direction for reconfiguration of the schedule of business and, if necessary, alteration of the Senate calendar for the fifth session to accommodate approval of the budget policy statement and the finance bills within the required period. Mr. Speaker, I urge respective committees to expedite consideration of pending business before them and to table reports pursuant to standing orders. I also use this opportunity to urge all senators to avail themselves this afternoon for the divisions on the 3 bills schedules in the order paper. Senators who have businesses listed are encouraged to be in the chamber to prosecute the same, including committee chairpersons and senators proposing amendments to bills listed in for the committee of the whole. Mr. Speaker, I thank you and hereby lay the statement on the table of the Senate. Thank you.
We have more statements. Thank you, Leader of Majority. Statement by Senator Wambua.
Thank you. Mr. Speaker, sir, I rise pursuant to Standing Order 48.1 to seek a statement from the Standing Committee on National Security, Defense, and Foreign Relations regarding the continued delay in allocation of a sub-county code in the Tharaka-Thagishu sub-county in Kitui County. In the statement, the committee should, 1, state the number of sub-counties in the country that were created in 2017 alongside the Tharaka-Thagishu sub-county, and how many of these sub-counties have since been allocated sub-county codes. 2, explain reasons for the delay in allocation of a code to the Tharaka-Thagishu sub-county, a delay that has meant that the residents who have suffered marginalization since independence continue to beg for services and to compete for opportunities with the neighboring Mumoni sub-county, and elucidate on the plans, if any, that the relevant ministry has put in place to ensure that the Tharaka-Thagishu sub-county is issued with a code in order to enable the residents have access to exercises such as Teacher Service Commission recruitment, military and national police service recruitment, distribution of relief support, among other national government services. Mr. Speaker, I thank you.
The next statement is by Senator Haron Cheriot.
Thank you, Mr. Speaker. Mr. Speaker, I rise pursuant to Standing Order number 48.1 to seek a statement from the Standing Committee on Lands, Environment, and Natural Resources regarding land transactions by multinationals without the involvement of the national or county governments. In the statement, the committee should explain the reasons behind the sale of expansive Lemotit flower farm in Londiani, Kericho County by a multinational firm, James Finlay Kenya Company Limited, stating whether the county government of Kericho was consulted and whether was consulted during the disposal of land, which is on a 99-year leasehold. Number 2, give the name of the individual or the company that has bought the said farm and state the use of the land that it is intended to be put into. 3, inform the Senate whether there is an intended sale of Unilever Tea Kenya Limited businesses in Kericho and Bomet counties. 4, state the compensation the two firms will grant their employees who will be rendered jobless by the sale of the said farms. 5, cause the Ministry of Lands to resurvey the land held by multinationals in Kericho and Bomet in order to establish the actual acreage of land hosting all multinationals. 6, state the policy and mitigating measures, if any, to be put in place to curb the land under the custody of multinationals without involvement of national or county government. Thank you.
Senator Cherargei.
Thank you, Mr. Speaker, for this opportunity. I want to congratulate and thank Senator Aaron Cheruiyot for bringing this statement on the issues of multinationals. I think Kericho, Nandi, and Bomet is largely affected with this issue of multinationals and tea leases and other forms of leases. I think since the 2010 Constitution, Mr. Speaker, the National Land Commission, the county governments and national governments have been silent, and they have not been telling Kenyans what happened with 999 leases that were committed to 99 years lease as per 2010 promulgation Constitution. I think this is very important, and I want to request the Committee of Lands and Natural Resources and Environment to expand and really tell Kenyans, especially from us in Kericho, Nandi, and Bomet, on the issue of leases, because there is a lot of secrecy. There is a lot of unclear, because, Mr. Speaker, we are aware that these multinationals have very huge control of tracts of land. And one day they can wake up and change ownership without the information of the employees, as Senator Cheruiyot has said, without the information of county governments, without the role of National Land Commission. I think a few months ago, I did request a statement similar, that we need to know the leases, because when you come to Nandi, most of the tea farms are owned either by individuals or multinational companies. So I hope this issue of leases must be told, be it sisal leasing, be it the issue of flower farm leasing, the change of ownership, who really owns? I think that should be the question. I think that even across the country, who are these leasing land? And we have seen, Mr. Speaker, if this issue of land ownership and leasing of land is not well coordinated, Mr. Speaker, I can assure you that will be a problem to this country. So I want to really support the statement and say that the issue affects us also in Nandi, and I hope, and then I know the Committee of Lands, Natural Resources and Environment has also a lot of issues to deal, but we hope it will give priority. Each one, every of us want to know what happened to 99-year lease, that it has been commuted to 99-year lease, and what is the role of National Land Commission, what is the national government doing? Because, Mr. Speaker, finally, as I conclude, most of these multinationals can only be dealt at the level of diplomatic level, and also can be dealt with the national government. Because most of these owners of multinational are either based in Britain or Europe or in America, Mr. Speaker. So it is also national government must be at the forefront of ensuring that they fight for us. They ensure that the issue of renewal of leases, change of leases, expiry of leases, the lessor and the lessee must be known. Who are they and how long do they have? Because in Nandi, Mr. Speaker, some of the leadership have been saying that that the leases have expired in 2014. It has now changed that it is expiring in 2023. I wish we would know when is it expiring, these leases, and ensure that we address issue of land historical injustice. I thank you, Mr. Speaker.
Senator Christopher.
Thank you, Mr. Speaker. I would like also to congratulate Senator Cheruiyot for actually almost reading our minds, because this particular issue of land leasing that has really affected Kericho, Bomet, and Nandi has become a thorn in the flesh of the residents of the people coming from those areas. And I want to say that, Mr. Speaker, we're still here over it's still rumor, and people would like to get clarification on the same matter, because we normally hear that the land has been leased once again for so many years. Yet we know traditionally or historically that this land used to belong to the community, to the people living in those particular areas. So you see, when they were displaced during the colonial period, most of them are landless people who are living in the Mau region. So when we hear, once again, that their land is being leased for another around 99 years, it becomes a problem to all of us, Mr. Speaker. And on top of it, the worst part of it is that the leasing was not done after evaluation of the land. The rates they are using is not known even to the community. So I want to say, we really demand to know those who lease this particular land without public participation of the communities surrounding these particular places. And you know, after leasing these particular places to different landlords, they came with different agenda. Say that most of them started planting flowers instead of the usual crops like tea, which used to employ a lot of people. And it has rendered so many people jobless. And I want to say that the communities that we live around those places, we are feeling it so bad. And to make the matters worse, Mr. Speaker, is that the assumption from the people outside there, even those well-wishers who would have wished to come and help our communities, normally thinks that we are the owners of those particular farms and we are very rich. Yet the contrary is the same, that the people from those areas are poor, but the assumption is that we are very rich and no one has ever been ready to help us. The farms that are leasing these particular places also does not have proper CSR activities to help the communities living in those particular places. So I want to say that leasing this particular land, once again, without involving our communities, is a problem, and we don't accept it, and we would like to call upon any committee meeting that will take over this one to do robust work so that we may know actually where the problem lies, so that our people may be assisted. I support this statement, Mr. Speaker, and I really support it fully. Thank you.
Senator Omanga, by virtue. Senator Omanga, your statement.
Thank you.
We can't
Thank
see
you, Mr. Speaker.
We can't see you, okay?
I'm on, Mr. Speaker.
We want to see you.
Yes, my video is on.
Okay, okay. We can see you. We can see two of you. Proceed.
Thank you, Mr. Speaker. I rise pursuant to Standing Order number 48-1 to seek a statement from the Standing Committee of Land, Environment and Natural Resources on the alleged irregular ownership and use of land number LR 336/64, originally land number LR 336/12 in Babandogo, Nairobi City County. In the statement, the committee should, 1, state the current land. Number 2, provide the current survey and deed plans of the piece of land under consideration. Number 3, investigate claims that the said parcel of land, which is public land, has currently been leased to a private individual entity. And finally, state plans put in place by Nairobi City County government to ensure all county-owned land parcels are secured and proper ownership documents acquired. Thank you, Mr. Speaker.
Thank you, Senator Omanga. Senator Irungu Kangata.
Yes, thank you, Mr. Speaker, sir. Mr. Speaker, sir, I rise pursuant to Standing Order 48, Sabbatical 1, to seek a statement from the Standing Committee on Land, Environment and Natural Resources on progress in compensating Kagaa Kilifi Landowners Group with reference to LR number 2859 and 1427 of Kilifi County. In the statement, the committee should, number 1, appraise the Senate on the progress made by the Ministry of Lands in compensating Kagaa Kilifi Landowners Group for land repossessed by the government for distribution to squatters. Number 2, state the reasons for the delay in finalizing the matter. Mr. Speaker, taking into account this land was owned by people of Murang'a County, in particular Kandara area, and squatters went there, and our people from Murang'a have been unable to realize the economic benefits of the said piece of land. Number 3, give timelines within which this process will be completed, tabling progress report and evaluation of the status of land settlement. And number 4, outline the measures that have been put in place, if any, to ensure that land disputes between the landowners and squatters or land ownership are swiftly dealt with. Particularly, Mr. Speaker, sir, this was a presidential directive. When Charles Rubia was being buried in Murang'a, I requested the president to help the people of Kandara to expedite this process. And that's why we are inquiring about the status. Thank you.
Another statement by Senator. You have two statements. Eh?
Thank you.
Yeah.
Mr. Speaker, sir, I rise pursuant to Standing Order number 48, Sabbatical 1, to seek a statement from the Standing Committee on Justice, Legal Affairs and Human Rights Committee regarding the appointment of private law firms to represent government in the Building Bridges Initiative case and payments made to them for the services rendered. In the response, the committee should, number one, explain the reasons the Attorney General appointing private law firms in the appeal seeking to overturn the judgment rendered in the High Court over the Building Bridges Initiative case. That is, in the High Court, Civil Appeal number E291 of 2021, Independent Electoral and Boundaries Commission versus David Day and 82 others. 2, confirm to the Senate whether the appointment of advocates met the required provisions of the Public Procurement and Disposal Act 2015, and 3, provide information on the payment made to them for the services rendered.
Thank you. Finally, Senator Rose Nyamunga.
Thank you, Mr. Speaker. I rise pursuant to Standing Order 47.1 to make a statement on an issue of general topical concern, namely the need to classify patients suffering from sickle cell disease as persons with disability. Mr. Speaker, sir, allow me to start by defining disability as restrictions in the type of activities and social participation that an individual can perform as a result of physical or mental impairment or conditions of long-standing duration within an environment that does not provide sufficient accommodation to facilitate participation. Mr. Speaker, the social model of disability focuses on the social context in which disablement occurs and identifies disability as the product of social disadvantage and exclusion. The purpose of this narrative is to highlight the malfunctional nature of disability among people with sickle cell disease, which includes physical, psychological, and social dimensions. Mr. Speaker, sickle cell disease is caused by a disorder in the hemoglobin component of blood, leading to abnormal sickle hemoglobin, which leads to sickle hemoglobin. The individuals with sickle cell disease exhibit significant morbidity and mortality rate. About 240,000 children in Africa are born each year with sickle cell disease, while here in Kenya, it is estimated that 6,000 children are born with the disease, which is a great threat to their physical and cognitive development. In sub-Saharan Africa, an estimated 50 to 90% of those born in the condition die undiagnosed before the 5th birthday. The recurrent pain and complications caused by the disease can interfere with many aspects of the patient's life, including education, employment, psychosocial development. Mr. Speaker, sir, the disease is common across Kenya with high disease burden pockets in Western Nyanza and coastal regions. In the Western region, it is estimated that as high as 18% of children are born with a sickle cell trait, and 4.5% will end up developing sickle cell disease. In the Lake region, it is estimated that about 17% of the children are carriers of the trait, which is 0.6% having a sickle cell disease, while in the coastal region, using impatient data, almost 1% of an inpatient almost 1% of inpatient children have sickle cell disease and are always 20 times likely to die compared to admissions to other mobilities. Mr. Speaker, sickle cell anemia requires ongoing treatment, medication, and hospital stays. By the time the sickle cell gets to a high level of severity to the extent of preventing the individual from working, it often leads to financial strain for both the individual and the family. Because sickle cell anemia is a disease that results in some form of physical disability, some persons suffering from it should be considered for benefits entitled to persons living with disability. Mr. Speaker, sir, due to the chronic pain in the bones and or joints associated with sickle cell disease, the individual often suffers from deficiency in mental and cognitive abilities, thus making it difficult to maintain concentration throughout tasks. Crises are common in many people with sickle cell disease, can cause significant fluctuations in the individual's ability to function in the workplace. Further, depression from recurring or chronic pain is common with sickle cell disease, which can lead to problems with performance, including concentration, keeping peace, remembering instructions, and interacting with others appropriately. Sickle cell disease patients incur other additional indirect expenses, including uncompensated care, premature mortality, lost productivity, and reduced quality of life, which are much higher than the financial figures. Having said the above, Mr. Speaker, I wish to implore the ministry responsible to consider classifying persons suffering from sickle cell disease as persons with disability. I thank you, Mr. Speaker.
Senator Musuruve.
Honorable Speaker, thank you for giving me this opportunity to support the statement by Senator Nyamunga on the issue of sickle cell as being a category of disability. One thing that must be clear, Honorable Speaker, that persons with disabilities have great challenges, and many times they cannot manage on their own without the support of others. And I want to say, Honorable Speaker, when we look at the issue of sickle cell, people who have sickle cell have enormous problems. They cannot manage on their own in various ways, Honorable Speaker. And some of the ways in which they're affected is that, that sickle cell, since it's a disease, and by the way, it is also called sickle cell disease. It has no cure at all, Honorable Speaker. And sometimes it leads to blindness, sometimes it affects the spleen, sometimes it affects the liver, sometimes it even affects, the oxygen, in the blood, and it leads to, visual impairment. So I want to say, Honorable Speaker, that these are groups of people that should be considered as persons with disabilities, Honorable Speaker. And I want to say, Honorable Speaker, that if I can take an example of albinism, it really took time for people to really accept that albinism is a type of, disability, because albinism comes with very many disadvantages. It can even lead to cancer, visual impairment and all that. In the same breath, Honorable Speaker, sickle cell can lead to visual impairment, and sometimes when it comes to developmental issues, people who have sickle cell have developmental issues, Honorable Speaker. So when it comes to sickle cell, it is a physical disability that actually should be considered as any other disability. And Honorable Speaker, in first world countries, people with sickle cell are even entitled to social security just like any other disability, Honorable Speaker. And I think Kenya, I don't even think, I know that Kenya is one of the countries that ratified, in fact signed and ratified the Convention on Persons with Disabilities. And since they did that, we are actually obligated with the international laws, and sickle cells ought to be considered as one of the physical disabilities that actually affect individuals, and they should be also able to get the services that the National Council is giving. The government is also giving, Honorable Speaker. And how to say, Honorable Speaker, even people with sickle cells go through a lot of discrimination. And even when it comes to even marriage and socialization, you'll find that most of them are not able to get married because of, the social perception of their disability and all that. And so there's just need to ensure that this category of people are actually embraced just like anybody else from a human's rights perspective approach, Honorable Speaker. I support this statement.
Senator Mogeni Eric.
Thank you, Mr. Speaker, for also giving me an opportunity to make a contribution. This is a statement that has been sought by Senator Nyamunga. At times, Mr. Speaker, we cannot fail to acknowledge how some of us can pick issues that many of us cannot think about. I've known friends who have children suffering from sickle cell, but I'd never imagined that a senator could elevate this to the level of it being a disability. And it's taken me sitting here and listening to the statement from Senator Nyamunga. And I think she has convinced me that these people suffering from sickle cell in society deserve to be placed in that level of people with disability. And Mr. Speaker, leadership is about addressing the concerns of the vulnerable in society, those in society who needs to be affirmed so that they can live some lifestyle which is a bit comfortable over and above the condition that is afflicting them. And I think, Mr. Speaker, having known families that have people who are suffering with this disease, I have no doubt that Senator Nyamunga this afternoon put forth a very strong case for this country to consider uplifting these people to the level of people with disability. Because, Madam Speaker, anybody who is suffering from a condition that is a lifetime.
I know you are referring to Senator Nyamunga's statement, but I'm the Speaker, not the Madam.
Sorry. This is the problem, Mr. Speaker, when you stay away for too long and you leave the seat in the hands of Madam Speaker. But sorry. Mr. Speaker. Mr. Speaker, I apologize. Mr. Speaker, anybody who is suffering from a condition that is lifelong, that is not curable, that causes pain, that makes them to feel discomfort, that makes them to behave in a manner that is not in tandem with a normal person, qualifies to be called a person who is suffering from some disability. And I think that is the medical condition that afflicts people suffering with sickle cell. These are people, for you to maintain them in certain lifestyle in society, you need to affirm them. For them to compete with people in certain classes of employment, they need to be affirmed. So I want to fully support the statement that has been sought by Senator Nyamunga, that let's place this class of people in the list of people who are recognized as people belonging to that class of persons with a disability, so that society can affirm them and treat them with some favorable condition than the way we treat some of us who are blessed to live normal lifestyle. So I support, Mr. Speaker, the statement by Senator Nyamunga, and thank her for having brought this matter to the attention of the Senate. I support, Mr. Speaker.
Finally, Senator Cherargei.
Mr. Speaker, I rise to support the statement by my neighbor, Senator Rose Nyamunga, and say, Mr. Speaker, anything that makes it unable for body to function properly or optimally should be considered a disability. And I think as a country, we have come a long way since 2003 when the Disability Act was passed by Parliament. I think we need to know that the traditional disability that all of us have known, like not be able to use your legs or ears or eyes. We should go beyond that. I think the world has moved on where now people living with sickle cell disease should be considered also part of disability, because these are people who have disease that makes them not to function optimally as normal as they should be. So I think when we are expanding and issuing the necessary either waiver or support, the way we do to people living with disabilities, Mr. Speaker, sorry, I don't know what is happening today. Mr. Speaker, is that we must agree that we need to, the law is already there, Mr. Speaker. We need to now look at the policy directions, the relevant ministries to come up with proper guiding legislative intervention, so that, and it is expensive also, Mr. Speaker, to live with a disease called sickle cell disease, Mr. Speaker. Most of them, the mortality rate is very high, especially when they are very young, if they are born with, as Senator Nyamunga has indicated. So I think what we just need is to realign the policy, the legislative intervention, and also to call out the government to include and ensure the people living with sickle cell disease, Mr. Speaker, are part of it. And number two, when that has been achieved, it will also be easy for them to receive medication, Mr. Speaker, because this medication is very expensive. It also affects one way or another, and you can see it's sometimes not because of genetics, Mr. Speaker. Most of the time can happen to anybody, and any parent who unfortunately has gotten a child who suffers from sickle cell disease will tell you that it's very expensive in terms of resources, in terms of time, in terms of medication. So it is not a disease that anyone would wish to anybody. And that is why the only humane thing that we can do is to ensure they become part of people living with disability, so that they can get those waivers, they can get government support, they can get necessary support from all agencies and state agencies, both in private and public sector. So therefore, I think I support and agree that this is part of also right to the health rights, Mr. Speaker, because everybody has a right to the health rights, and I think it is very important. So I really want to thank Senator Nyamunga for bringing this issue up. I know many Kenyans who have lived with this disease appreciate this and call upon I have had Senator Msuruve, who is one of the representatives of people living with disability, and I think she will be among working closely with this House, and also Senator Rose Nyamunga, to ensure that the relevant agencies take this matter with seriousness it deserves. I thank you, Mr. Speaker, and support.
Senator Mudhama Agnes,
Thank you, Mr. Speaker, for giving me this opportunity to contribute to this important bill by Senator Mwamunga.
Okay, we can't see you. We need to see you.
Mr. Speaker, sir, I concur with my fellow senators that these people living with the sickle cell go through a lot of trouble, and especially the parents. The parents, when they are living with these children, they go through a lot of trauma, and they spend a lot of money, because time and again, these children lack blood. And so every now and then they are taken to hospital for infusement of blood again.
Maybe we have challenges with the system. In the meantime, Senator Cheriot. Senator Cheriot.
Thank you, Mr. Speaker, for this chance. Mr. Speaker, sometimes I wonder, how difficult is it if we decided as a country to have a general attitude, those of us in leadership, be it in legislature and in the executive, to simply focus on the needs that are most pressing on the citizenry. Things to do with health, for example, and specifically focus on diseases that ordinarily pick on people who don't have the ability actually, such that if you do not meet the cost of medication, then it's a difference between life and death. I brought to this house 2 or 3 weeks ago a petition also from citizens living with automotive diseases, almost similar to this challenge of sickle cell. And the simple request which the petitioners are making, which is almost close to what I hear Senator Rose Nyamunga requesting and wanting to know from the committee, can't we use our national health insurance cover to ensure that we put parents of many of these young people, or even those who have grown into adulthood with it, under universal health care coverage, as such that on every occasion when they visit hospitals and they have these institutions that are able to accept NHIF as a means of payment, they are treated and they go back home peacefully. On many occasions, Mr. Speaker, you'll find all these people come back and plead to us, at least each one of us, because I know this, Mr. Speaker, out of personal experience, that almost every leader in this House knows 1 or 2 or even more parents who are faced by this challenge. They cannot meet the cost of medication, and therefore they resort to calling upon you once in a while, say, oh, my child has had an attack, please just see that which you can raise. And of course, out of human nature, you'll be able to mobilize a little bit resources for them. But I believe if we properly organize the NHIF, Mr. Speaker, and it's good because that act is before this House, and I believe part of the reason why actually the Committee on Health need to expedite and ensure that we do not go on the long recess in the month of December before concluding business on that NHIF Act, is so that it addresses some of these issues like the autoimmune diseases and this sickle cell, so that we expand the base. As it has been said, and I have read through the economic model that is being proposed by Dr. William Ruto about the bottom-up, is that it makes absolutely no sense for Kongo Mogeni, who earns 1 million Kenya shillings, to pay 1,700, just like any other ordinary citizen who's above, I think, 40,000 Kenya shillings a month. It's not fair. I believe those of us who earn more should be able to pay something not so exorbitant, but at least something slightly better that will ensure that this health insurance scheme has more resources and are able to take care of needy Kenyans, such as the ones that are sending this statement via our colleague, Senator Dr. Rose Nyamunga. Therefore, Mr. Speaker, I hope, just as a way of answering this statement, Mr. Speaker, that the committee will also find it in its place to expedite the conclusion of that NHIF Amendment Act that is before this House, so that we can be able to reform NHIF appropriately and ensure that we cover as many Kenyans as possible. Look at the miracle that has happened, Mr. Speaker, for example, when they started paying up for patients of renal failure. Many of them are able to access dialysis service in our county referral hospitals, and that has been a big change to them. It's actually the difference between life and death to many of them who would have otherwise never have been able to meet the cost of the treatment or the dialysis in private institutions. But now, because of what was done to NHIF, they are able to take care of it. Perhaps there are challenges here and there in our counties, but it's not as good as, it's not as bad as was the case before then. Therefore, I plead with the Health Committee, Mr. Speaker, to expedite that business because it means a lot to our citizens. Thank you, Mr. Speaker.
Thank you for your statement. Senator Agnes Zani House, just closing. Okay. Yep.
Thank you, Mr. Speaker. I wish to support this statement from Senator Nyamunga, and that she's really touching a very important category of people who already by the very nature of their disease have really been disadvantaged. We have many people with sickle cells, and they cannot be 100% productive. It's a struggle. It's very expensive as well. So if there's a way that in terms of health they can be covered so that they can be taken care of and lighten their burden, then this is definitely the way to go. And the way to see it, Mr. Speaker, is that way then you really save in terms of economic development for our country, educational development, and all sorts of developments which are very, very critical. I think it's just very important that the committee that will be handling this looks at all parameters that make it very difficult for various people to join such programs. And I know we are not yet at a place where we have a safety net for all Kenyans in terms of the specificities of the diseases that they have or the disadvantages that they have. Indeed, our social protection program has not been as developed as other countries, and this is the direction to go. And I think this is one step in that direction. I thank you, Mr. Speaker.
Senator Naomi, I was just, okay. You're the last one on statements.
Thank you. Thank you, Mr. Speaker, sir, for allowing me to add my voice to this very important statement by Senator Nyamonga. And I want to also congratulate her for bringing up that very important statement whereby many Kenyans are affected by sickle cells, and many Kenyans are also taking care of the children who are suffering from sickle cells. Mr. Speaker, I support this statement because of the challenges that those who are affected by sickle cells are going through, and because as a country there is need for us to take care of every Kenyan, and the proposal made by Senator Nyamonga is quite important and relevant because they need a lot of support from the government when you are nursing a child who is suffering from this. And when maybe you are also suffering from the disease itself, you need a lot of care, you need a lot of protection, you need caregivers around you. And most of the time, even the medical care is quite expensive. And unless we come up with a program that takes care of them, then they will be very vulnerable in our society. And therefore, I stand to support the statement and pray that one day they'll be considered as people living with that. Thank you.
Okay, Honorable Senators, that brings us to the end of our statement hour. And I would want, for the convenience of the House, I want to rearrange the order paper and skip all the way from order number 8 up to order number 20. So order number 20, Senator Mogeni was moving the motion. So I'll tell you how much time you still you have. How much time?
Order number 20, motion, adoption of the report of the Standing Committee on Justice, Legal Affairs and Human Rights on a statement sought by Senator Mutula Kilonzo Jr. regarding delays in the appointment of judges of the High Court and the Court of Appeal. How much time? You have 39 minutes.
So, Senator Morgan, you have 39 minutes.
Thank you, Mr. Speaker. Yesterday, when we were joining, I was just trying to finish giving historical background on the history of this country on this matter of appointment of judges. And I think I was about to now go into the current legal framework governing the appointment of judges. Mr. Speaker, Chapter 10 of our Constitution comprehensively addresses the mechanisms through which judges are appointed. And Mr. Speaker, what is being considered in this statement is whether the recommendations of the Judicial Service Commission are binding to the President. It has got men of high caliber, high credibility, and people are holding very senior positions in the country. The membership is 11, Mr. Speaker, and you can see that when Kenyans were enacting their constitution in 2010, they were very keen that they should place the responsibility of nominating judges on Kenyans who are honorable and who can be up to task in exercising this responsibility. The chair, Mr. Speaker, is none other than the Chief Justice of the Republic of Kenya. Then we have a judge of the Supreme Court, who is a member. Then we have a judge of the Court of Appeal, who is a member. And then we have one High Court judge, who is a member. And then we have one magistrate, who is a member. Now, what should capture the attention of Kenyans is that because people wanted this process to be as credible and as independent as possible, all these representatives of the judiciary are elected. So they are picked in a democratic manner through an election that is conducted by the judges of the various branches of the judiciary. The Supreme Court does their own election, Court of Appeal, High Court, and the magistracy. So the process is in hands of people who have an independent mind. They are not an appointee of anybody. However, Mr. Speaker, so that the interests of the president are taken care of, there are also some appointees who are members of the Judicial Service Commission. The first one, Mr. Speaker, is the Honorable Attorney General. He's supposed to take care of the interests of the president in the Judicial Service Commission. But because, Mr. Speaker, Kenyans never intended that the president just becomes a puppet in this process, the Constitution has also given him a leeway. If you read Article 171, sub-Article 2, H, the president also appoints two Kenyans, single-handedly, without placing any adverts in the newspapers. He picks two Kenyans who are supposed to represent the public in the Judicial Service Commission. That gives him 3 members. And then he is also allowed to pick one other appointee, that is from the Public Service Commission, who also sits in the Judicial Service Commission. So in total, the president has 4 representatives who can adequately represent his interests. And also to give this process more credibility, Mr. Speaker, the legal profession in this country is also allowed to pick 2 nominees. Again, Mr. Speaker, these nominees are picked through a democratic electoral process. And these elections, all lawyers know, are normally conducted by the IEBC. That's how serious that this to the legal profession, to the members of the public. Further, Mr. Speaker, the procedure of appointing or recommending persons to be appointed judges is also regulated in this Constitution. Mr. Speaker, if you read Article 172, sub-Article 2, sub-Article A, the process of sending these nominees to the president must be done in a competitive and transparent process. Therefore, JSC is obligated to place adverts in the newspapers, conduct interviews before they forward the nominees to the president. Then, Mr. Speaker, the Constitution, if you read it, binds the president to, I think that's Article 161. Yeah, 166. The president shall appoint a Chief Justice and other judges in accordance with the recommendation of the Judicial Service Commission. So what one can infer from the clear reading of the Constitution is that the president has been given very little leeway when it comes to picking names of judges who have been recommended by the Judicial Service Commission. It simply means that if there are 10 slots, Judicial Service Commission will recommend 10 persons from whom the president must appoint judges. Madam Speaker, we were able to also look at what the courts have said in terms of interpreting these articles of the Constitution. And Madam Speaker, we we realized that this matter has been a subject of litigation in a number of instances. The first one, Madam Speaker, is when there was a nominee for the position of Chief Justice, that is retired Chief Justice Maraga, and the Judicial Service Commission forwarded one name to the President. But there was a proposal that the Judicial Service Commission ought to have sent 3 names from whom the President should have picked one. Again, this matter was heard in the High Court, and a 3-bench judge made a finding that the Constitution obligates the Judicial Service Commission only to send one name. This matter was litigated all through to the Court of Appeal, and the Court of Appeal affirmed that position, that only one name should be sent to the President. Again, in this particular matter, Madam Speaker, this matter has been subject of litigation in our courts of law. In fact, there are so many cases pending before court. But I'll just cite one case where the High Court constituted a bench of 3 judges, and in a judgment that was issued on the 6th of February 2020, this is what the High Court ruled. First, the High Court made a declaration that the President is constitutionally bound in accordance with Article 166(1) and Article 172(1) of the Constitution to appoint all persons recommended for appointment by Judicial Service Commission. Number 2, Madam Speaker, the High Court made a declaration that the failure by the President to appoint the persons recommended by Judicial Service Commission is a violation of the Constitution and the Judicial Service Act. Finally, the High Court ruled that any continued delay to appoint persons recommended as judges to their respective courts is a violation of Article 2, Subarticle 1, Article 3, Subarticle 1, Article 10, Article 73, Subarticle 1A, Article 132, Subarticle 2A, Article 166, Subarticle 1, Article 172, Subarticle 1A, and Article 249, Subarticle 2. Madam Speaker, this judgment is a subject of appeal, an appeal to Her Excellency, the Honorable Chief Justice, to move with speed and constitute a Court of Appeal bench that should expeditiously hear and finalize the appeal that has been filed by the Honorable Attorney General. Madam Speaker, we made a comparison with the situation that prevails in one of our democracies in Africa, that is South Africa, and we drew a distinction with what prevails in South Africa. Madam Speaker, Section 174 of the South African Constitution obligates the Judicial Service Commission of South Africa to forward 3 names to the President for each vacant position. Unlike what prevails in Kenya, where the Constitution does not give room to the President to pick from 3. So this argument, Madam Speaker, that we should send 3 names to the President has a very clear distinction when you compare the South African Constitution and the Kenyan Constitution. Because in Kenya, it just tells JSC to make recommendation to the President, and then the President appoints. Madam Speaker, we also drew distinction with what prevails in India. Madam Speaker, in India, the Prime Minister has a discretion to reject with reasons a nominee that has been forwarded to him by the Chief Justice. The appointment in India is that the Chief Justice with 4 senior-most judges sits down and makes recommendation to the Prime Minister, but the Prime Minister, by dint of the provisions of the Indian Constitution, can reject a nominee with reasons and return the name back to the Chief Justice to renominate another person. So it seems, Madam Speaker, that when Kenyans were enacting their new constitution in 2010, they were very clear what they wanted. And I think it's because of the historical background taking into account the fact that the Kregler Commission, Kofi Annan report, the Boma's draft constitution, and the committee of experts had all made recommendation that we should have a judiciary that is independent of the executive. I think that's what informed the chapter 10 on the constitution. So, Madam Speaker, having looked at all these issues, there are a number of problems that we have identified. The first one is that when we wrote to the Judicial Service Commission, they wrote a letter to us to the effect that when they were in the process of conducting interviews, they received a letter from the NSIS to the effect that a number of candidates had some integrity issues. But when the Judicial Service Commission wrote back for details, they were never given details. Therefore, they formed an opinion that it would be in violation of the Constitution, more so Article 47, on a fair administrative action to condemn the candidates who had applied to be appointed judges on allegations that had not been disclosed to the Judicial Service Commission, and on allegations that had not been disclosed to the candidates, so that they are given an opportunity to respond to those allegations. And they say this is contrary to the Bill of Rights, which obligates every Kenyan to be given a fair hearing when faced with any accusations. Madam Speaker, this committee recommends that the best practice should be that if there are any allegations facing any candidate, the most decent position should be that the Office of Attorney General should have those allegations reduced into writing with specificity. Then the candidates are confronted with those specific allegations, and then they are given an opportunity to respond to those allegations. Since that was not done in this particular case, Madam Speaker, it is the conclusion of this committee that it will be a violation of Article 47 to condemn candidates who had applied for this position without being confronted with those specific allegations and being given an opportunity to respond. In fact, there's even a bigger problem, Madam Speaker. 4 of these candidates are serving as members of the High Court of Kenya, and they continue to serve as members of the High Court of Kenya. Now, the 2 other candidates are serving as magistrates in the Republic of Kenya. And all these 4 candidates have not been confronted with any allegations warranting their removal before the Judicial Service Commission. And we have made an observation, Mr. Speaker, that this is a fairly untidy situation, because these members continue to dispense justice as judges of the High Court of Kenya, but with this kind of blanket condemnation that is facing them. Now, there is another observation we have made, Madam Speaker, that it is inhuman to continue condemning these judges unheard while they continue serving as judicial officers. Madam Speaker, the judges risk suffering serious reputation risk on account of their continued non-appointment. And we pose this question, Madam Speaker. What do you think is in the minds of litigants who appear before these judges as they continue reading these reports in the newspapers that these judges and the 2 magistrates have never been appointed because they have some integrity issues? And remember, this has been this matter has been pending for the last 2 years. So we have made an observation, Madam Speaker, that to the judges who have not been appointed, what we are subjecting them to is tantamount to some psychological torture, which is against our Constitution, more so taking into account the period that this matter has been pending. So we are appealing to the President to look for a solution out of this impasse. If there are any credible allegations against these judicial officers, then the most decent thing to do is to forward those allegations to the Judicial Service Commission so that the process of removing these judges, if at all, can be commenced. And this is because, Madam Speaker, there is no any other way you can deal with a judge who is in office and other than making a complaint before the Judicial Service Commission. And this is captured, Madam Speaker, under Article 168, sub-article 4 of our Constitution. And it says that a petition by a person to the Judicial Service Commission under sub-article 2, that is on initiating a process of removal, shall be in writing and must set out the alleged facts constituting the grounds for the judge's removal. And that's what we are saying in our report, Madam Speaker, that anybody who wants these judges investigated for whatever reasons must set out these facts in writing so that these judges are confronted with these allegations and they are given an opportunity to respond to these allegations. And it says that in Article 4, it is the Judicial Service Commission that has the final say. So even if anybody was to file a complaint to the Judicial Service Commission, again, the Judicial Service Commission must sit, consider the merit of that allegation, and then make a decision whether it warrants the setting up of a tribunal. And Madam Speaker, this is captured in Article 168, sub-article 4. The Judicial Service Commission shall consider any petition presented to it, and if it is satisfied, so it must be satisfied. You can have allegations, you may think that particular judges ought to be removed, but it is up to Judicial Service Commission to be satisfied that the grounds being presented warrant the setting up of a tribunal to remove judges. So unless this process has been invoked, Madam Speaker, these judges will continue to enjoy security of tenure. Another thing we have observed, Madam Speaker, is that the Kenyans, when they enacted their constitution in 2010, expected that anybody who is given a task, an obligation to perform a certain task, will perform that task within a reasonable period. And this is captured in Article 2, I think it's 259(8), if I can read it to the House, Madam Speaker. 259(8) says, if a particular time is not prescribed by this Constitution for performing a required act, the act shall be done without unreasonable delay and as often as the occasion arises. Now, the matter that is under inquiry relates to a process that was concluded in July 2019. Now, the first bunch of judges were appointed in June. That is close to almost 2 years after their names were forwarded to the President for appointment. And what this committee is saying, Madam Speaker, is that it seems that this Article 2598 can be abused. Because reasonable time, somebody can say it's 1 year, it's 2 years, whatever. That's why we have made a recommendation, Madam Speaker, that this House considers amending the Judicial Service Act so that a period is prescribed within which the President should appoint judges once recommendation has been forwarded by the Judicial Service Commission. And at times, Madam Speaker, events happen that trigger, at times constitutional amendments or amendments to statutes. And I remember if I'm not wrong, the 16th Amendment in the United States of America in 1912 that triggered amendment to the American Constitution to allow for direct election of senators arose because of the corruption that was happening within the state parliaments. Where business people are now buying positions of senators, because the position before 1912 was that the state parliaments are the ones that used to appoint a senator. And that process was abused till the Americans decided in 1912, to do their 17th Amendment and allow for direct nomination direct election of senators. So I think even for us, maybe a time has come when we should consider whether we should amend the Judicial Service Act so that we have a clear timeline. Whether we want to say it's 60 days, it's 90 days, whatever period. But this committee is recommending to the House that the Judicial Service Act should be amended so that there is a timeline prescribed within which the President should take action. I think another moment when the Americans responded to address a problem was in, I think, 1951, the 22nd Amendment. Because, Madam Speaker, when George Washington was elected as the first President of the United States of America, he put in place this precedent that the President should serve for 2 terms. And that became the practice for so many years, till in the 1930s, when President Franklin Roosevelt decided to seek a 3rd term and was actually elected for the 3rd term as President of the United States of America. And in response, in 1951, America had to pass the 22nd Amendment to put a term limit on presidential tenure and say no president will be elected for more than 2 terms. So it's nothing wrong. At times, experience can lead us as a country to start reflecting whether a time has come when we should do some of these amendments. So, Madam Speaker, having made those observations, my committee made the following recommendation, which we seek that this House adopts. The first recommendation is that His Excellency the President, without any further delay, should proceed to gazette the appointment of the 6 persons nominated by Judicial Service Commission for appointment as judges of the High Court of Kenya, and whose names were omitted from the Kenya Gazette of 3rd June 2021. That's Gazette number 124. Madam Speaker, we looked at all the academic qualifications of these judges, and we have no doubt that they meet the professional qualifications. The Judicial Service Commission complied with the Constitution. Advertisements were placed in the newspapers. The Kenyans were invited to make comments and views on the non-suitability of these judges. The judges were interviewed in a competitive exercise, and as allowed by Constitution and by law, the Judicial Service Commission recommended the people they deemed to have been best qualified to be appointed as judges. In the process, Madam Speaker, we made an observation that the person who is conducting litigation on behalf of the government, that is the Office of the Attorney General, was actually a member, and he participated in the interview and the final decision that was arrived at by the Judicial Service Commission. And therefore, this committee made an observation that he is bound by the decision that was made by the Judicial Service Commission. In the event that he wants to continue litigating in court, this committee proposes that the Attorney General invokes the provisions of Article 156, Sub-Article 7, and designate some officers independent of him to exercise some of the roles, including conducting the litigations in court, so that he doesn't find himself in a very awkward position before the Judicial Service Commission. So it's the hope of this committee that the son of Kapkatet, Kericho County Justice Weldon Korir, the son of Malindi Village Wisero, Kakamega County Justice Muchelule Hagre Osiula, the native of Kisumu County Honorable Justice Odunga George Vincent, the native of Cagiado County Honorable Justice Joel Mwaura Ngugi, and the son of Kisii County, Ivacho Village Nyaribari, Evans Kiago, and the daughter of Kisumu County, Judith Elizabeth Omange. The latest decisions from the High Court. But we have now a decision that has been issued by the High Court to the effect that the Chief Justice should proceed to assign these judges their duties, and they should process their salaries and benefits as judges of Court of Appeal and judges of the High Court, respectively. Madam Speaker, though this matter has now found its way to the Court of Appeal and a stay has been issued, we think that the President should find a way of getting an amicable solution in these battles. And at times, Madam Speaker, people can disagree. I know if you look at the American history, there are some gentlemen who participated in the writing of the American Constitution, the founding fathers of America, John Adams and Thomas Jefferson. They were very good friends, Madam Speaker. But in course of time, they joined different parties. I think John Adams became a Federalist, while Thomas Jefferson remained a Democrat. And they became serious adversaries. They could not talk to each other. One served as a second president, but he was succeeded after one term by Thomas Jefferson. But with time, they found that it serves no purpose to have all these disagreements, and they became the best of friends. In fact, Madam Speaker, they died on the same day, on the 50th anniversary of American independence, having become great friends. So even in this particular situation, the President has led the way in uniting the country by having a handshake with the Right Honorable Prime Minister Raila Amolo Odinga. We really hope that even in this particular situation, we can find a way of having a sitting with the Chief Justice so that some framework on bringing this debacle to an end is found. It's not very healthy, Madam Speaker, for the country to see the kind of disagreements between these two branches of government. We want the executive to be independent and the judiciary to be independent, but to continue serving the interests of the country. So in conclusion, Madam Speaker, this report by my committee is founded on the fact that this committee believes that it's very healthy if we promote the rule of law, and if we also respect our constitution and our statutes. Therefore, we are appealing to the head of the executive to put in place steps of bringing this disagreement between these institutions to an end. We want to thank the staff of Parliament, the Office of the Clerk, who assisted us with research in compiling this report, and for the time they put in compiling this report. And I also want to thank all the members of my committee who are very useful and helpful in compiling this report. With those many remarks, Madam Speaker, I beg to move and kindly ask Senator James Orengo, Senator for Siaya, to second the report. Thank you, Madam Speaker.
Thank you, Senator. Minority Leader, Senator James Orengo.
Thank you, Madam Speaker. I support this, and Madam Speaker, it may later on occur that probably this report and the subject we are dealing with is a very, very important issue that defines what Kenya should be or what Kenya is at the moment and which direction we are going. It is critical, and I'll give my reasons why. Madam Speaker, in the year 1787, when Benjamin Franklin, who is very well known, he's in the popular culture, was walking out of the Independence Hall, out of the Constitutional Convention in 1787 in the United States of America, somebody asked him when he was walking out of the Independence Hall, and asked him the question, "Doctor, what have we got, a republic or a monarchy?" And Benjamin Franklin retorted, "A republic, if you may keep it." This remark by Benjamin Franklin has been cited many times, but more importantly in the last 1.5 years in the United States of America, when they have gone through experiences that even an old modern republic like the United States, they have wondered whether they were moving in the right direction. And people like the Speaker of the House of Representatives in the United States of America, the well-renowned Madam Pelosi, who is the Speaker of the House of Representatives, has used this remark by Benjamin Franklin in issues that have arisen in the United States of America, particularly after the elections that they held in the year 2020, when the American Republic, in a way, was also suffering for so many challenges. And a republic is a government by the people through its elected representatives. And it is not just through its elected representatives as portrayed in Article 1 of the Constitution of the Republic of Kenya. It is actually a government based on the sovereignty of the people. And therefore, Madam Speaker, all of us in public offices and heading important institutions must be guided by the law and the Constitution. Must be guided. You know, this great debate between in the Greek democracy, do we have a government of men or a government of laws? And constantly in modern democracies, it has been found you are better off with a government of laws as opposed to a government of men. And men here is men with capital M, Madam Speaker. So if you look at the context in which our Constitution was drafted and enacted, it was through a period when the executive was amassing power, and even the judiciary. And I think in Parliament we made statements. Me personally, I kept on quoting a British judge who kept on saying that, the judiciary and judges should not be more executive than the executive. This is the context in which our Constitution was founded, that through the years, in the last 40 years, our experience has been, which is not very different from the colonial days, that the judiciary was becoming more and more a tool of the executive. And the provisions that my chairman has referred to on how you appoint judges, and particularly the Chief Justice, was born out of this context. Because, before, the president used to appoint the Chief Justice, used to appoint the judges, and in fact, what would have probably mirrored what we should have in Kenya today is that we should have had an American system where the president appoints and the House approves. And if the House does not approve, the thing goes back to the president. But because of the experience we had in Kenya over the years, where the judiciary was becoming more executive than the executive because they owed it to the executive to get those appointments, it was found necessary to put provisions in the Constitution whereby the Chief Justice, the manner in which he was being nominated and appointed, did not require a decision of the president in determining who becomes the Chief Justice. Instead, it was the Judicial Service Commission which would determine who would become the Chief Justice, and the matter would be brought to Parliament, and after Parliament approves, then the responsibility of the president was to exercise authority of being an instrument of appointment. The president does not make that decision. The president is an instrument for appointing, the Chief Justice. I, for one, would have wanted it to be like America, really. If a president has a program to fight corruption or to bring in new laws that measure up to his vision and go to the people and be elected on the basis of that vision, probably it would be better for the president to appoint, and then Parliament would approve. But unfortunately for Kenya, there were fears that, if this responsibility is left to the executive, and sometimes the executive can be controlling Parliament, in order to have a strong judiciary. And the experience is that a strong judiciary is very, very important for a democratic nation to grow and for it to observe the rule of law and protect the Bill of Rights and the freedoms that may be enunciated in its constitution. And therefore, I would plead with the President of the Republic of Kenya that there is no way we can circumvent the Constitution. There's no way, literally. And I think, Senior Counsel Okongo Mugeni, and I wish Amos Wako was here because he was there when they were debating this, that this is a matter which we cannot circumvent the law, really. There's no other way. There's no other way. There's no other possibility. And the Attorney General should advise the President sufficiently that once the Judicial Service Commission has made recommendations and nominated people for appointment, the duty of the president then is to appoint. And nobody should be afraid to do so, because in the Judicial Service Commission, the representation from the executive is top-heavy, led by no other person of distinction than the Attorney General, who is the advisor to the president as an advisor to government. So that when a matter goes through the Judicial Service Commission and the country has concerns, or the president has concerns, or the executive has concerns, the executive has people within the Judicial Service Commission who can raise these issues. The Attorney General, there are 2 appointees by the president in the Judicial Service Commission, and there is the Public Service Commission. These are bodies and persons who can actually put before the Judicial Service Commission any fears that the executive may be having on appointment of judges. And because the Judicial Service Commission is a constitutional organ also, the only judges that are actually appointed by approval of Parliament are the Chief Justice and the Deputy Chief Justice. The rest are appointed by the Judicial Service Commission, and the President's role is to appoint those who have been nominated by the Judicial Service Commission. And I know this is a matter which it does not even arise just from this constitution. Under the old constitution, the president was required to appoint 12 nominated members of Parliament, the National Assembly then, and those appointed were supposed to reflect gender balance. And the nominees were made by political parties. This matter went to court one time, and I remember representing FIDA in court on the question of appointment of nominated members of Parliament. And FIDA was complaining that they were not getting a fair representation out of those 12 nominated members of the National Assembly. And the debate that time, Madam Speaker, was not really about whether the president was ready or willing to appoint, or whether he was going to appoint those nominated by political parties. It was a question of numbers. Do we have 6 men and 6 women, 6 men and 6 women? Or the word gender equality gave some discretion. But it was never an issue that arose that the president could replace or refuse to appoint those who are nominated by the political parties. So on this particular issue, it defines us as a nation. It defines us as a nation. Can we make appointments in accordance with the Constitution? I mean, for example, if after an election I'm elected as a member of the Senate from Siaya, and then the Electoral Commission is given discretion whether to nominate me or not. Once the election process takes place, the only question that can arise whether I'm properly elected or not is in court. Is in court. And once I'm elected, or any person is elected, the duty of the Electoral Commission is to gazette those who have been elected, and then somebody can go to court and make a challenge. And the fact that you go to court does not mean that then there's a preliminary stay or injunction against that person assuming the seat. And therefore, Madam Speaker, I really don't understand this. It's one of the things that is defining us. It's something that we are taking very lightly, but it is defining whether we are persuaded ourselves that we are a government that is guided by the Constitution and the law, a democratic government based on justice and the values and principles in Article 10 of the Constitution, or we still want to cut corners. And my view, Madam Speaker, is, in fact, my views are very strong about this, particularly when you look at even the judges concerned. And I don't want to, I may be accused, but some of the judges who were nominated to go to the Court of Appeal, they are some of the most brilliant jurists. And I think Senator Mugeni would agree that somebody like Judge Justice Odunga is one of the best judges, hardworking, brilliant. I know he's been accused of so many things. I've also been associated with him. Some people said I'm related to him. God forbid. I've never even stepped in Judge Odunga's house, although he comes from Uganda. But you go to the legal community, if you go out there, they will tell you, even people who used to say things about Justice Odunga, and I remember what Duale used to say about Justice Odunga. But recently, he has also said that, Justice Odunga is one of the most brilliant jurists that we have in this country. I may disagree with Justice Ngugi on his decisions as a lawyer, and this is normal. This is normal. But I cannot run away from the fact that he's one of the most brilliant jurists that we have in this country. A Harvard-trained lawyer, and he's not just carrying that flag that is Harvard-trained. He's a brilliant judge. Justice Korir. All these justices, if they cannot qualify, then I don't know which other judges can qualify. I don't know. And the worst thing, Madam Speaker, is when you are being told there is something in your life that disqualifies you from being a judge or assuming a public office, and you're not being told what it is. Nobody's telling you. Even the Constitution now requires that, if you're going to make a decision that is adverse, Article 47 of the Constitution, that if you're making a decision that is adverse to any person, that person is entitled to know why that decision is being made. Now, I think for some people who may believe that we are saying these things, to undermine whatever we are trying to go through this transition, that is not the case. Some people sometimes bring arguments that are stupid, that are silly, when you are dealing with an important issue like this one. The other case, and Madam Speaker, I want you to look at what Miguna says about me. All over, every day. He doesn't say nice things about me, at all. And I have no war with him at all, and I know why he must say it. I may disagree with him. But there was a decision by the courts going up to the Court of Appeal. And our government has failed to comply with those decisions of the court, which has gone to the Court of Appeal. And the executive knows that some of his senior officials were fined by a court of law. And they appealed against that fine in the Court of Appeal. And they had to pay the fines for disobeying court orders. So Madam Speaker, I would really plead with the executive that if we want to move forward in the vision of this constitution that we have, obedience of court orders. You may disagree with court orders, and people disagree. There's a process of disagreeing. There's a process of disagreeing. And the worst thing is if the executive is disobeying court orders. If the executive is disobeying court orders, then why should ordinary people disobey court orders? Should obey court orders? They should not be obeying court orders if the government which is supposed to obey court orders is not obeying court orders. Madam Speaker, I remember once when we went before the High Court, under the leadership of Jaramogi and Muliro and Shikuku, when we wanted to go to Kamkunji. And we were seeking a decision from the High Court, challenging the directive by the police that we could not hold a meeting. We decided to withdraw the case because we knew that if the court made a decision, then we were required to comply with that decision of the court. And we were trying to tell Kenyans, that we want to build a new Kenya based on democracy and the rule of law. And we could not see ourselves that after that court case, if the judges made a ruling that, we cannot go to Kamkunji, that then we disobey the court order. So what we did was to withdraw the case and then went to Kamkunji, and the rest of it is history. So I think, my chairman, this is one of the issues that you should not run away from it. I think you should continue to be on this matter. And I didn't sign the report because I was away when the report was being signed. But it speaks volumes that the Attorney General Emeritus also signed this report. And I'm sure that if he was available today, he would be making a great speech why Kenya will go down the drain if we don't find it as part of our system, judicial system, based on the rule of law, that the highest powers in the land can disobey court orders without a consequence. I find then there's no need, we should not have the courts at all. I think we should abolish the courts if court orders are not going to be respected. And the other bad thing which the chairman emphasized, once you find that a judge cannot qualify to go to the Court of Appeal on grounds of integrity, then that judge should not even sit in the High Court or hold office, any judicial office. So why is the government comfortable standing on the way for these judges to move to the Court of Appeal or to move to those judicial offices? But the government is not doing anything about their staying in the offices that they occupy now as judicial officers. We should be having petitions for their removal, if indeed there's concrete evidence against these particular judges. I really plead that the foundation of a democratic society, the guarantor of a democratic society, is our courts and our judicial system. I've been following quite a lot of what is happening in the United States of America, where there was an insurrection on the 6th of January this year. And you find that even judges that were appointed by Trump, going against the wishes of, the appointing authority or whoever was responsible for appointing them, because they believe in the rule of law. So this is a matter which personally, generates a lot of emotion from me. Madam Speaker, I appeared before a judge called Justice Dugdale, who was just an instrument of the executive, and I was addressing the court. He wanted to arrest me. for what I'm saying in court as a judicial officer. And he was very comfortable saying that because he knew he was an instrument of the executive. There was my friend who was chairman of the Law Society, Kamau Kuria, of the people who really fought for this new constitution. Kamau Kuria's name should be, high in the first 10 or so. And a judge took a file relating to a matter which Kamau Kuria had filed in court. I think it was in relation to, the Bill of Rights. And a judge, because he knew the executive wanted that matter to be decided in a certain direction, and he could not deal with it the way he should. So what he did was to keep the file. He just hid the file, just sat with the file. And eventually, when the file was released, he said, the Bill of Rights could not apply because rules under the Bill of Rights had not been made, and therefore there was no basis to approach the court under the Bill of Rights. That's not the kind of society we want to build. And Kenya should be at the top in this region in advancing the rule of law and constitutionalism. And I would join my chairman in pleading to the president and to the people involved and to the Attorney General that really this is a matter that is embarrassing. And the fact that you're going before the same courts and the same judges to try to plead on a matter which, in the truest sense of the word, there is no basis, there's no legal basis for challenging that decision. I think it makes ridicule of what we're trying to do and what we fought for, to have this constitution that we have that makes Kenya, everywhere you go, people are talking about this constitution as one of the most important documents to come out from this part of the world. Now, we don't want a document that is respectable because of what it says, but we want a document that can change our lives. It's a transformative legal document. It is creating a new society, a new man in Kenya. And that is why, Madam Speaker, even at the time when this constitution was being proclaimed by President Kibaki at Uhuru Park, we were talking about a second republic because we had a new constitutional order after the old constitution was retired. So without going beyond what I've said, I think I've made my point. Madam Speaker, I second and support.
Thank you, Senator. I now propose the question, which is that the Senate adopts the report of the Standing Committee on Justice, Legal Affairs, and Human Rights on a statement sought by Senator Mutula Kilonzo Jr. MP regarding delays in the appointment of judges of the High Court and the Court of Appeal laid on the table of the Senate on Tuesday, 19th October 2021. Senator Kithure Kendike online. Can you have Senator?
Honorable Speaker, can you see me?
I can hear you. Yes, I can see you.
Thank you, Honorable Speaker. Madam Speaker, I cannot hide my tremendous admiration on the quality of this report, which forms the basis of this motion. I cannot hide my admiration at the leadership of Senior Counsel Okongo Mogeni and the entire Committee of Justice and Legal Affairs and Human Rights of the Senate. Honorable Speaker, I was a delegate at the constitutional making process, the conference at Bomas of Kenya in 2004, 2005. A very lengthy process. At that time, I was representing the academia as a young legal scholar. I participated in the debates, especially on the chapter on the judiciary. And therefore, I want to completely associate myself with all the sentiments that have been made by the mover of the motion, and also the seconder of the motion, Senior Counsel James Orengo, whom I respect a lot and who has actually highlighted the historical context in which the quagmire which we find ourselves today as a reason. Honorable Speaker, the recommendations of the Judicial Service Commission to the President are binding on the President, period. He has no room to maneuver. He has no room to wriggle out of the names that have been given to him. And the authority for that is Article 166 of the Constitution that says that the President shall appoint the judges in accordance with the recommendations of the Judicial Service Commission, not in accordance with the recommendations of the NIS. Honorable Speaker, the role of the President is appointive and is ceremonial. It is not functional. The recruitment agency of judges or for judges is the Judicial Service Commission. It pains me, therefore, as an officer of the court, to see some of the brightest and greatest judicial minds that this country has ever produced. My lords, Justice Odunga, Justice Ngugi, Justice Muchelule, and Justice Korir, being dragged through a protracted name soiling simply because of a presidency and an executive that thinks that they can rampage around the country and take over and seize over the functions of each and every constitution. You take over the judiciary, you take over parliament, you take over, increasingly they are actually going into county government. They have taken over Nairobi, and I'm sure they will be interested in taking over the other 46 counties if they had an opportunity. Honorable Speaker, we are coming from a very dark past. There are times when the judiciary was completely immobilized. Criminal charges of great Kenyans like Senator Orengo and other second liberation fighters would be dragged to court at 6 p.m., taken through what I would call a kangaroo process, sentenced the same night, or detained without trial. Honorable Speaker, in 1988, Kenya changed its constitution to remove the security of tenure of judges. In the aftermath, we witnessed a very dark situation where it was rumored some judges who were handling sensitive cases would carry draft judgments to State House for approval before they could read out the judgment in court the following day. That is the background we put in place, the very strict measures in the chapter on judiciary, chapter 9 of the current constitution, which has made the wielders of power extremely uncomfortable. However, we are not out of the woods yet, even with the new constitution. Recently, we have seen my Lords Justice Muchelule and Justice Chitembwe arrested in their chambers. Yet we know that the chambers of a judge are inviolable. And any suspicion of a commission of crime, there are ways in which the same can be handled without violating the sanctity of the courtroom, because a judge's chamber is also a courtroom. Some of the decisions, motions, and applications are actually had in chambers. So a judge's chambers, a judge's office is actually a courtroom. It's like actually entering a courtroom when a judge is proceeding and arresting a judge. Honorable Speaker, I believe that the president can be forced to do what he has refused to do by an order of mandamus. I say so because an order of mandamus is an order that is normally given to a public officer who has refused to perform a public duty. And I believe in the appointment of judges, the president is actually duty bound to do so, because Article 166 says the president shall appoint in accordance with the recommendations of the GSC. So an order of mandamus actually could force the president to do so. And if he doesn't do so, then other measures can, as I'm going to show shortly, can set in. Senator Orengo has just mentioned about a time when you could not enforce human rights in this country simply because the old Section 82 of the retired Constitution provided that the Chief Justice was supposed to make rules for the enforcement of the chapter on fundamental rights and freedoms. And the Chief Justice never published those rules. And so courts could not enforce human rights simply because the Chief Justice has refused to do a public duty, which is merely administrative and not decisional. It's not judicial. So similarly, even for the judiciary, there are certain acts that they are supposed also to be held liable. This immunity of the judiciary applies in functionally. And by that, Madam Speaker, I mean when they are performing judicial functions. For example, if the Judicial Service Commission is hiring judges, that's a judicial function of that commission, and so forth and so on. But for example, in matters like procurement, the judiciary should be held accountable if there are procurement anomalies in the usual standards that are applied to other institutions. So, Honorable Speaker, I believe that an order of mandamus could apply in the case, and I'm very disturbed as I see a creeping notion, which is not based on any law, on the infallibility of the president. And I recently participated in some proceedings in the Court of Appeal where I had very weird arguments by very seasoned lawyers about certain levels of infallibilities of the president on a different matter of immunity of the president. So I think time has come for us to stand firm, and I want to thank this committee for coming up with such a robust report. And I want to maintain that the president's role is ceremonial. If he doesn't appoint those judges, what should happen is what the High Court has already decided, that since this is a ceremonial function, the most important part for these judges is the taking or the swearing in, and they can be sworn in before the Chief Justice, and then automatically they become appointed. I associate myself with that judgment, although now it's pending appeal in the Court of Appeal, and I think the reasoning is quite solid. Most likely the Court of Appeal or even the Supreme Court is going to uphold that logic. Honorable Speaker, the same case applies to legislation. If the president, and that one is already in the Constitution, we don't have to do anything about it. If the president, for example, refuses to assent to a legislation passed by either the National Assembly or the Senate or Parliament jointly, if he doesn't assent, then within 30 days, that law is presumed to have been assented to. And that is what the logic that is applying in this issue of appointments. We cannot hold this country backwards and delay justice simply because of an administrative function, which can be dispensed with. I want to say 2, 3 very quick points, Honorable Speaker, so that I give other people an opportunity to contribute. I would like to say that the issue of the report of the NIS, Senator Omogeni has told this House that the Judicial Service Commission told the committee that the National Intelligence Service had objected to the appointment of certain judges, but when they were asked for particulars, they were unable to provide those particulars. They made the allegations blanketly without giving the particulars. I want to submit, Honorable Speaker, that such an action is egregious and is an affront to the old canon of natural justice. Natural justice, which presumes that nobody should be condemned unheard. It is not only against natural justice, but also it is against the very direct provisions of Article 47 of the Constitution, which provides for fair administrative action before a decision is made. I want to conclude, Honorable Speaker, by saying, going forward, it is not our argument, it is not our submission that judges are infallible, they cannot be questioned, they cannot be held criminally liable, or it is not our argument that whatever judges say or do is always right. What we are arguing is that the chapter on the judiciary under the current Constitution gives very strong protections on the judiciary to enable them to deliver on their functions. Any person, therefore, who has an issue with either of a criminal nature or adverse nature against a judge, the procedure is not to arrest a judge inside his chamber or inside the courtroom. The procedure is first you initiate the process of removal of that judge. A tribunal is established. Once a tribunal is established, then the judge is suspended. Once he is suspended, now you can drag them to court, charge them. If they are found guilty, then they face the consequences of the law. If they are acquitted, they can even be reinstated back to office. It is therefore a pity, Honorable Speaker, to watch, for example, my lady Justice Muiru, the Deputy Chief Justice and Vice President of the Supreme Court of our country, being dragged through the humiliation of facing a magistrate court on criminal charges relating from what appears to me a purely civil matter. How on earth do you walk into the chambers of the Deputy Chief Justice, drag that person screaming and take them to court before a magistrate? How do you expect even that magistrate to behave? So the procedure should be, if Justice Muilu has committed an offense, if Justice Muchelule or Justice Chitembo have committed an offense or suspected to have committed offenses, they must be reported to the JSC, which will recommend a tribunal. A tribunal is set up, charges are brought, and during the proceedings, that person will stand suspended so that we don't indignify the hallowed corridors of justice. This is a timely report. I support it fully, and I hope that we will going to see many more of this kind of products. Once again, congratulations, Legal Affairs Committee. Congratulations, Senator Omogeni, Senator Orengo, Senator Amos Wako, and all the great lawyers and other colleagues who are serving this committee. I support.
Thank you, Senator Kindiki. Senator Oshilo Ayako. Senator for Migori.
Thank you, Madam Speaker, for giving me an opportunity to remark on and support this report. Madam Speaker, in terms of longevity, in terms of time, Kenya is a young nation when we look at the lives of our institutions. We have, by international standards, a young judiciary. We have a young presidency. We have recent jurisprudence. And therefore, we need to get it right, and extremely right, from the beginning and throughout. It must be right. If we get it wrong, then we don't seem to benefit from precedents. We don't seem to benefit or to desire to benefit from practices from jurisdictions that are similar to ours. And that seems to be the case. Madam Speaker, any person, anywhere, anytime, who exercises authority, who holds an office, must understand that the holding of that office, the exercise of that authority, and everything related to it derives its legitimacy from law. So you cannot just emerge from somewhere and purport to exercise authority or purport to do something if it is not founded on a law. And that is what is described the rule of law as the rule of law. So, Madam Speaker, we have a presidency, we have a judiciary, and here we are in a legislative body. The authority that is exercised by these three arms of government must be only that is granted by the law, permitted by the law, and limited by the law. Anything outside that one may be wishful, may be arbitrary, and should not be countenanced in any decent society. So, Madam Speaker, the issue that is germane in this report is whether the rule of law is being followed. For those who politic and love to cheer on leadership, even when the exercise of powers attributable or associated to such leadership may actually are advised to ensure that the power and everything that is done by such leadership is founded on law. If it is not founded on law and it is arbitrary, then it becomes abuse of office. So let us look at the issue here. The issue here is the presidency. The issue here is the authority of the president or the role of the president in appointing judges. The Constitution is clear when you look at it plainly. The president purports to be acting pursuant to the same Constitution, but his action is not founded on any law that can be pointed out, but it's founded on an interpretation that is by himself and that does not enjoy the agreement or the support of the judiciary. So the president reckons that some judges that he is supposed to declare appointed, because his work is to declare that they are appointed, are unsuitable for office, and that information has emerged from an entity whose mandate in law does not include commenting on such matters. So, Madam Speaker, this is strange. This is extremely strange, because if such actions are allowed, then you will find that those who advise the president or any entity purporting to advise the president can be granted by the same president, although the law does not envisage that, some imaginary powers to purport to advise the president to violate the law. So, Madam Speaker, there may be sound thinking, not lawful thinking, on the part of the president that it is important to check the backgrounds of judges. But until legislative institutions are persuaded, until the citizens of this nation are persuaded through a referendum that they should amend the law and grant the president the powers that he purports to exercise now, the desire of the president to have authority to reject recommendations of the Judicial Service Commission on the appointment of judges is purely a dream. It's a fertile dream, but it can only become a reality if the law as enacted by this parliament, or the law as enacted by the people of Kenya through a referendum is made to pass and is authorized in the manner that is supposed to be authorized. Until that is done, this is an illegality. It cannot be any other thing. This act is unlawful, whether because the presidency is such a monumental institution continues to do so, it remains unlawful, and all of us who are charged with the responsibility to defend the Constitution, to defend the rule of law, and to ensure that right overrides might, will always stand in this House and say no to such impunity. On that note, I want to give accolade once more to my friend, neighbor, and colleague, Senior Counsel Senator Okongo Omogeni, together with his galaxy of membership of his committee, comprising some of the best brains in legal matters that we have in this House. I think their work is a piece of work that this House should be proud of. And I want to say again, without fear of contradiction, that the voters may be having their thinking out there, but if they were to deny this House the knowledge, the dedication, and the experience of our colleague Senator Okongo Omogeni, together with Senator James Agri Bob Orengo, Senator Emeritus A.G. Amos Wako, and all the participants in this committee, this parliament will be poorer. Kenya will be poorer in terms of institutional staffing, in terms of capacity, and I therefore appeal to those who can persuade those voters that please return these persons to this House unopposed, unless they decide to go and serve Kenya in other offices. That would be voluntary. But if they were to offer themselves as candidates for re-election, I would ask God to do something to the electorate to ensure that they are returned, because it is really right and it's really courageous to stand firm and tell the presidency that you are wrong and that you are being wrong or outside the law is backed by this thinking and by the statutes that are mentioned within the report. Now, having said that, Madam Speaker, I also want to say that And I had said it earlier that we are a young democracy with young institutions. If you look at what is happening in court, you will find that most of the judgments that are being delivered in court regarding the other co-equal arms of government are judgments that appear to be vengeful. They appear to be pushback. If you look at yesterday, we were discussing what the judiciary was trying to visit on the Senate when a dispute was emerging between Senate and the Council of Governors. It appeared to be a pushback. It appeared to be a slap on the Senate. If you look at some of these judgments that the judiciary is delivering on matters of presidency, it appears to be a pushback. It also, they appear to be a slap on the face of the executive. Such things arise when there is a clear indication that the executive has an agenda against the judiciary. That there is a clear indication from the executive that some matters will be revisited. When, at the beginning of your term, you unsheath your dagger and tell the judiciary that you will met the sharpness of that dagger against them right into their hearts and twist it. Judiciary, being occupied by human beings who live in Kenya and coming from a history where judges were arbitrarily arrested and detained, when previously their tenure was taken from them and they were serving at the whims of the executive, they are bound to hit back. They are bound to push back. So being a young democracy, we need leadership that will act beyond emotion, that will act beyond vengeance, because institutions, when they are young and being established, they need to run their matters in a clearly objective and focused environment where there isn't attempts at pushback. Because when such things happen, you will find that the sufferers, or those who suffer most, are the innocent and helpless interest of our nation and nationals. So, Madam Speaker, I want to say that the President should, or the Presidency, should actually think about the impact of this fight against the judiciary, and the judiciary should similarly think about anything that might be perceived as a pushback. This kind of situation where there is a standoff between or among the arms of government may render government dysfunctional, because it is presupposed that although all the arms of government are independent of the other, but they must cooperate. They must work together so that the nation becomes functional. So this flagrant violation of law as to the appointment of judges may have a reaction, may have or occasion a reaction or a resultant and desired consequence where the judiciary may take a step or a measure that may be in some gray areas. And I do not want to particularize or give specific examples. And what happens then? What happens is that this nation, because of such impasse, will grind to a halt. This nation, because of such quarrels, may be rendered unfunctional or dysfunctional. You can see right in this house, we describe the majority side as also the ruling party, and that is what Jubilee is to all of us. And right across the aisle where we have Senator Linturi, you will find that he will claim that he is not a member of Jubilee, And the undesired consequence is that Jubilee, de jure, is the majority side that is dysfunctional because of its internal quarrels. That can also give indication that we may have institutions that are legally there, but because of these shadow boxing or these fights that are coming up, this one has clearly been initiated by the president and the judiciary for its own survival. We may also do something that causes paralysis. Then we end up suffering. And one of the sufferings that I suspect we are undergoing now is the insufficient funding and delayed exchequer releases that are given to the judiciary. The people of Migori, where I come from, have so many pending cases. They do not have in Migori County, for instance, a court that deals with labor-related matters. We have to travel all the way to Kisumu and queue on the benches in Kisumu. People from Kakamega County have to travel all the way to Kisumu. People from Vihiga, from Busia, and perhaps from Trans Nzoia. People from Kisii, people from Nyamira, and you may just discover that there are 2 judges there. One single case that is of limited value, pecuniary value. It may be a dispute over 10,000 shillings. It takes as much time as a dispute that is of millions or billions of shillings. So, Madam Speaker, you can see the suffering that we Kenyans are experiencing because of this standoff. How I pray that these bulls that are fighting, assuming the judiciary is a bull and the executive is a bull, would understand that it is the grass they eat that makes them function. In other words, the citizens of these nations are the taxpayers and the donors of the mandate, the donors of the sovereignty they enjoy. So they must start thinking about the welfare of the citizens and do something that will not occasion endless suffering among us as citizens of this country. I know that those in authority like us desire something called judicial accountability. But until we put it in law, this remains the law, and nobody can imagine that they have some better reasons to create their own laws, to create their own precedents, to create their own authority, and try to apply something else that is unknown to law. And until we establish how we legally want to carry out judicial accountability, this kind of behavior by the executive, and specifically by the president, should not be tolerated. Because if we tolerate this, then there is no way of standardizing what is called judicial accountability. Maybe next time when Senator Linturi becomes president, and I hope that somebody someday after Tinga from Mount Kenya East becomes the president, and it should be Senator Linturi, then he also comes with his own methodology of judicial accountability. Then this nation will be as uncertain as the number of presidents or executives that we have. So I want to appeal in conclusion to the executive to put the interest of Kenya first, Kenyans first, and the nation first, then ensure that the law as it is, the law that put you in office, is adhered to strictly without trying to create some imaginary authority or some imaginary method of accountability and subject our judiciary to such imaginary or whimsical manner of accountability. I also want to appeal to our committee to start thinking of how to introduce judicial accountability, how to introduce it legally, how to debate it, to involve everybody, including the judiciary and all Kenyans. And when we have it, then When it is agreed to by all of us and it is the law, we all follow it. But for now, we must condemn in the strongest term, in the strongest language, firmly and swiftly, what the president is doing against the judiciary, and ask for the judiciary to be measured and restrained when it comes to pushback. Thank you very much, Madam Speaker. I beg to support this report.
Senator Linturi Francis Mudhika.
Thank you, Madam Speaker. Madam Speaker, before I move further, let me correct you in one way. I am not Francis. My name is Franklin Mithika Linturi. So it's important to have that corrected from the answer. And Franklin Mithika Linturi is my name. Madam Speaker, let me take this opportunity to first thank the Committee on Legal Affairs, Justice and Legal Affairs for their bravery, their explicitness in coming up with the recommendations that they have made in this report. It takes great men of good courage and strength, considering the circumstances that the country is in, to come out forcefully with very great ones, though kind, to differ or to disagree with a position that has been taken by the executive and stand strongly in defense of the Constitution, the rule of law, for good order in a country like Kenya. Mr. Speaker, Madam Speaker, I say this because the people that sit in this House, the 47 elected and the nominated senators, you remember, going by what our mandate is, I think we have a clear mandate to protect the interests of our people that belong to our counties. And I believe that when the framers of our current constitution and when Kenyans decided on the 27th of August 2010 to give themselves this constitution, there was from a background, an history of bad governance, an history that was not so good, and Kenyans wanted a new order in the country because before then, judicial independence was not there. The manner in which there was abuse, the Speaker, you realize that we have an obligation as leaders and as citizens to defend this Constitution. We have our rights in this Constitution. There is nobody who is above the law under this Constitution. And Parliament, the Executive, and the Judiciary, as its mandate clearly defined in the Constitution. Mr. Speaker, anybody, any state officer who has sworn to defend this Constitution and has the greatest responsibility to live and abide by the law and basically because of the office that one owns. The standards that are expected of behavior, the standards that are expected of conduct of an MCA are different from what the public expects from the member of Parliament and the Senate, and is different from what is expected of a president. Mr. Speaker, the report from the Justice and Legal Affairs Committee relates to a breach of our constitutional duty by the President to appoint judges that have gone through a very, very rigorous selection exercise by a constitutional body by the name the Judicial Service Commission, whose mandate or part of its mandate is to recruit judges and make recommendations to the President for appointment. I think it's important to mention and to note that in the membership of the Judicial Service Commission, the executive is represented because the Attorney General sits as a member in that commission. And when people apply for appointments as judges, either of the Superior or of the High Court, the Court of Appeal, I believe, and there is a notice that is always published, so that any Kenyan who has any information that may probably make it impossible or that would disqualify any applicant from appointment of that particular office be shared with the recruiting body, which is the JSC. This happened. And the reason why that is done is so that the people that are of questionable character, the people that have history of not standing by the rule of law or cannot be defenders of the law, not find themselves seated in that particular office. So, Mr. Speaker, it leaves us wondering, when such elaborate mechanisms are in place and the President himself, because he's the end of the executive, is represented in that body by the Attorney General, and he participates in that recruitment, agrees that certain judges must be appointed, then the President refused to do so. The President has a constitutional duty to obey the law. The President has no basis or no business not appointing judges once the Judicial Service Commission has recommended for the appointment. And the reason, one of the reasons is that for the judiciary to have its independence, to avoid the manipulation by the executive, and that is why I personally think, and one of the reasons should be, that he should and must appoint the judges once recommended by the Judicial Service Commission. So the idea and the explanation and the excuse given that some of these judges are of questionable character, Mr. Speaker, is unpalatable, cannot fly, because this country has even an NIS that should have told the President before these people. The names were submitted, and this and that issue, and for that matter, that information should have come or gotten itself before the JSC. Once those names have been published and known, there is that aspect of legitimate expectation from the judges. Yes, we've done well, and the JAC has accepted us, and for that matter, we are going to ascend to an higher office if you are a court of appeal, a high court judge, or if you are practicing advocate, or anybody else that will be getting to that particular office. So, the kind of impunity we are seeing in this country, the kind of carelessness in terms of obeying court orders by the executive and the president himself is something that we must stand up against. I want to reiterate the fact that, and I hope he's listening, and whoever listens for him, that this country, there is nobody who is above the law. There is nobody. And when you have a constitutional duty to fulfill, you must do it. And let me say, Mr. Speaker, if you are to look at the reasons or the grounds for impeachment of a president, you realize one could be gross misconduct, a failure to live and abide by the law or the Constitution, to uphold the Constitution. And if you are to critically look at what his actions have been, what he has done, failure to appoint judges, and to obey other court orders, in my view, constitute gross misconduct, abuse of office, and, in my view, are impeachable offenses. But because we have a weak parliament, we have people are afraid, people have been intimidated, and almost turning this country into a dictatorship. Nobody is willing to take up that responsibility. I want to say that I am grateful and happy, even if it doesn't serve any purpose. There is proper record in this Senate that once, that in the year 2021, there was a committee on justice and legal affairs that found the president to have broken the law.
Senator Nturi, you are saying this is a weak house. Is that what you're saying?
I have said we have a weak parliament. And Mr. Speaker, with a lot of respect, please, I stand and I can substantiate what I am saying, but let me also remind you that the impeachment process of a president does not start in this house. So that process starts in the lower house, which I'm saying is weak. It has no muscle. They cannot do it. And that is the problem, one of the major problems, because if we were in other developed democracies, then this should have commenced or should have happened. So, Madam Speaker, I and Mr. Speaker, my good friend suggested that
what is it, Senator George Ochilo?
Mr. Speaker, thank you. Mr. Speaker, we are all members of this august House, and you have heard our brother here mention that we are a weak house, and that the other house is also weak. Mr. Speaker, these things are being recorded, and history will remember that it has not been challenged. Now, I want to ask our good friend that in the absence of substantiation that we are a weak house, and he needs to do so, then he should withdraw those remarks, because record will bear it out that we are acquiescing to his assertion that we are a weak house. The report that has been brought by our committee is a very powerful report. He is discussing a very powerful report. A powerful report cannot be made by a weak house. I am a very powerful senator, and Mr. Speaker, you are a very powerful speaker. How dare he claim that you are weak when you are seated there? and that Madam colleague of yours, Madam Speaker, is also weak. So he has to explain that so that my daughters now and in the future will know that their father was not in a weak house.
Mr. Speaker, how I wish that my good friend Senator Yako was listening. Because what I said is that we have a weak parliament. And I further went and sent the National Assembly, because the impeachment process of a president does not start in the Senate. That's what I sent. And until that process has started and has come here, you cannot know whether the mandate that is before us, or our mandate, will be properly executed depending on the matter that is before us, until such a motion is here. So, for avoidance of doubt, and for purposes of making you understand it better, you need to understand the context in which I was saying that we have a weak parliament, a weak National Assembly, because if they were not, then whatever action the president has committed constitutes an impeachable offense, which should have commenced if we were strong. But so that I don't lose my thought processes, Mr. Speaker, Senator Yako mentioned the fact that we do not have judicial accountability. I want to reiterate that the judiciary, I think, is fully accountable. And remember, the judiciary is insulated by our own constitution to the extent of the judgments that are made, judicial judgments or findings that they make, and we have a system of how we can check errant judges through the normal judicial appeal
What is it,
processes.
Senator George Ochila?
Thank you. Mr. Speaker, my colleague is misquoting me. I said that what the president attempts to be doing is to introduce judicial accountability outside the law. And if there is a need to have that judicial accountability, this committee should think about it, process it, and make it lawful. So it should not be recorded that I am attacking the judiciary. So I wanted, on a point of order, to ask my friend to have the record reflect that, so that nobody quotes me there as being part of the mercenaries attacking the judiciary.
Senator,
probably, the chair, remember I came in when he was
in Article 96.5, it says that it shall be out of order for a senator to criticize or call to question the proceeding in the National Assembly, a county assembly, or the Speaker's ruling in the National Assembly, but any debate may be allowed on the structures and role of county assembly or on the National Assembly. I hope you are dealing with the matter to do with the structures and their roles.
Give me the mic. Sorry. Mr. Speaker, that is exactly what I'm doing, because, you know, there are no proceedings on this matter, on the impeachment of a process of the president in the National Assembly. So what I'm discussing is the manner in which we are structured. Probably there could be structural weaknesses, which I'm trying to address by debating this report, participating in this report. So judicial accountability. Mr. Speaker, there's nobody who is not accountable. And to the extent that judicial decisions have a process under which you may differ with them, in my view, that is proper accountability. Judicial officers are accountable for the money that is given to them by Parliament, because they have an accounting officer and who presents his budget before the committee, before the budget and
Senator
appropriations committee.
Linturi, Like how many minutes would you want to be added because you interrupted? How many minutes would you want to be added so that you can finish?
I think I lost around 5.
Okay.
Yes. So I hope.
Okay, so I give you 3 minutes.
So, Mr. Speaker, this is a very important report. And I once again want to commend Senator Omogeni for really coming up with this report. Let it go on record that the defense of our judiciary is paramount, is important, and we cannot loosen the guard. Mr. Speaker, if we were to do that, then we'll get back to that era where people would even be taken to court at night, pronouncements will be made, and people will be put into committee at night. So for whatever it takes, we must defend the independence of the judiciary. And one of the reasons why I believe we need to is because we cannot allow competent, very intelligent men and women in this country who serve, or who are supposed to serve in the judiciary, may end up losing their position from serving the wananchi in this country because of the perceptions, probably, or how they are taken to be inclined. And finally, Mr. Speaker, Mr. Speaker, let this report be aligned towards the necessary legal reforms that probably we may require to make so that that ambiguity, if there is any in the Constitution and in the law, is addressed in the future, because we cannot be sure who our next president will be tomorrow or even in the next 20 years, because the institution of the judiciary is what we must jealously guard, Mr. Speaker. Thank you, Mr. Speaker.
Thank you, Senator Inturi. There being no any other request, I call upon the mover to reply.
Thank you, Mr. Speaker. I first want to thank all the contributors who have contributed to this motion. Senator, Senior Counsel James Agri Orengo, Senator Professor Kidure Kindiki, Senator my learned friend Ochilo Ayako, and Senator Mithika Rinturi. First, I want to appreciate the kind words from my colleague senators, but I want to reiterate, Mr. Speaker, that as a lawyer, I've been privileged to rise and serve my country as a president of Law Society of Kenya. Therefore, Mr. Speaker, there is no title that I wear more proudly than being a defender of the rule of law. Mr. Speaker, in a situation like the one at hand, I have no choice other than to put my country and the Constitution of the Republic first. I have no choice, Mr. Speaker, other than to bear true and undivided allegiance to the Constitution of the Republic of Kenya, which I swore on the floor of this House to defend. Mr. Speaker, on a matter that is touching on the independence of a key institution, like the judiciary, I cannot afford to have divided allegiance to the Constitution of the Republic of Kenya. Mr. Speaker, on a day like this, the 11th day of November 2021, having been privileged to be elected as the senator for the county of Nyamira, I'll want the children of my children, my grandchildren, to know that when I was confronted with a choice between ignoring the rule of law or standing on the side of the rule of law, I chose to stand on the side of the rule of law. When confronted with a situation where I would have chosen to have a divided allegiance to the Constitution of the Republic, I chose to bear true allegiance to the Constitution of the Republic of Kenya. Therefore, Mr. Speaker, I want to thank the contributors who have spoken in support of this motion, that as lawyers who are serving in this House, we must continue to remind the executive that they must respect and uphold the Constitution of the Republic of Kenya, which we have all sworn to bear allegiance to and to respect. Mr. Speaker, I cannot agree more with what my learned colleague, Senator Orengo, has said this afternoon about the brilliance of some of the names of the people who have been proposed to be judges. And I want to disclose, Mr. Speaker, that some of these proposed judges were with me in the University of Nairobi. Proposed Justice Evans Kiago Makori, a native of Ivacho village in the Kisii County, was my classmate in the University of Nairobi. And Mr. Speaker, is one of the few students that won our admiration in the class of 90 to 93, because Mr. Makori is an inspiration from his village back home. From Form 1 all through to Form 6, he attended an Arambe school called Ivacho Secondary School. In fact, we used to crack jokes in campus those days. And we used to ask him why he chose to go to somebody's home and call it a school, because nobody knew Ivacho High School or Ivacho Secondary School. That's how hard he has fought to reach where he is. If you read the website of the Judicial, you will see that Magistrate Evans Makori has been a force behind many of the reforms that have been witnessed in hearing of cases. He's the one who started digital hearing of cases while serving as a chief magistrate in Mombasa. Magistrate Judy Omange was 2 years behind me in campus. And we used to crack jokes that she hailed from a district, then we used to call them districts, from a district where professors are counted by the number of professors per square kilometer, from Seme. And I know there are some people in this who are serving in the legal department in this house who are our classmates. And I want to affirm, Mr. Speaker, that native of Seme is a brilliant lawyer. She was a very active member of the law club at the University of Nairobi. Justice Odunga, I believe, was a classmate of Justice Ochilo Ayako.
What is it, Ochilo Ayako?
Just point of information. It is true, Senator Omogeni, myself, were in the university at the same time. Justice Odunga and I were in the same class, and he is a person of impeccable integrity. He is a person, even if you look at his wealth as a person, it is something he has truly earned, and is also a person of courage. Courage is one person who will say that thing is red and means that it is red. He is not a person who is made to call a toothpick a comb or a comb something else. Thank you, Mr. Speaker.
So, Mr. Speaker, you can hear that confirmation from Senator Ochilo that we are talking about lawyers of high integrity, people who enjoy a lot of respect among their own peers. Justice Odunga was one class ahead of me, and he led a very simple life. Mr. Speaker, he struggled to find his way to university. He's one of those few Kenyans who maybe would have not made it to university if there was no help to assist Kenyan students from poor backgrounds to go through higher education. But if you talk to lawyers, just as it was submitted on this floor by Senator Orengo, Justice Odunga has written one of the most brilliant judgments you can ever find in the High Court. One of the most brilliant, well-reasoned, well-written judgments, comparable to a leading judge we call Lord Denny in the legal profession, Mr. Speaker. And the same can be said of the other judges. Weldon Korir was a pioneer in the Judicial Review and Constitutional Division. And let me say that I've appeared before Justice Korir and lost some cases, but not because he had any biasness against me, but because I didn't have a good case, and I cannot have anything personal against him, Mr. Speaker. Therefore, I feel the pain, the way Justice Orengo said. If you have unknown allegations hanging over your head, and you are a judge dispensing justice for a period of over 2 years, it is the kind of torture that you do not want to subject any human being to. And I want to state on the floor of this House, Mr. Speaker, that we will one day in our lifetime need a judiciary that is fair, that is ready to dispense justice in a very fair manner. And that's what some of us are trying to fight for today. Long after we have left this House, long after those who are serving in the cabinet have left, long after even His Excellency the President has left office, he still needs an independent judiciary that is guided by no any other consideration, but by the need to dispense justice in a fair manner. And I'm proud that the senators who spoke today are unanimous that they want to defend the independence of the judiciary. And we have examples we can learn from, Mr. Speaker. In America in 1804, President Thomas Jefferson was elected through a very popular mandate, one of the highest. He had 162 electoral colleges out of a possible 176, one of the highest ever. But when he went into office, he had a bone to pick with the judiciary. And he thought because he had control of the House of Representatives and the Senate, he thought he could engineer an impeachment of some of the judges whose opinions he didn't like in the Supreme Court of America. And he tried with a district judge, and that worked. Then he moved to the Supreme Court, where he wanted Justice Samuel Chase to be impeached. And he had the numbers from his party, the Republican Party. He had the numbers. And he wanted to remove Chase because he was appointed by George Washington. And he thought George Washington did not make a very wise choice. And Mr. Speaker, in many of the evenings when the impeachment was going on, he called members of his party, the Republican Party, to go to State House for dinner, to enjoy tea, so as to influence them in making a vote that will lead to the impeachment of Samuel Chase. But because the senators were mindful of how important it is to have an independent judiciary, they disagreed with their party boss and they voted to reject the impeachment of Samuel Chase. And that went a long way in maintaining the independence of the Supreme Court and the entire judiciary in the United States of America. In 1933, Franklin Roosevelt had a commanding majority. In fact, out of 435 members of the House of Representatives, the Republican Party had only 89. The rest were Democrats, 333. In the Senate, out of 100, he had 76 senators from the Republican Party. In fact, the sitting arrangement could not fit one side of the House, so the Democrats had to sit on the other side of the Republicans. And he said he was very annoyed with some of the decisions the Supreme Court was making because it was nullifying some of the New Deal decisions, some of the legislations that Roosevelt had proposed to address the issue of depression that had hit America hard that time. But some of them were declared unconstitutional by the Supreme Court. And to deal with that big-headedness, in quotes, from the Supreme Court, Roosevelt proposed to amend the Constitution, increase the number of Supreme Court judges by adding another 6 so that he could pick his own judges to dilute the independence of the Supreme Court so they can stop declaring unconstitutional his legislations. But, Mr. Speaker, if you read history, you will confirm that despite that commanding majority that Roosevelt had, despite him going out to campaign to influence the decision of the Senate, despite that commanding majority of 76, Mr. Speaker, the Senate refused to go by that proposal of the president, and they rejected that proposal. In fact, it ended in a very tragic happening, Mr. Speaker. The leader of majority, Senator Robinson, who was pushing that agenda on behalf of the president, was so shocked that on the one evening he retreated to his apartment and he died of heart attack. Tragic end to that campaign. But still, the Senate stood on the side of protecting the independence of the judiciary. And that's why this afternoon, Mr. Speaker, I speak with passion and conviction that this country is safer with a judiciary that is independent, that is free of political manipulation. And I want to agree with what Senator Uchilo has said, that it is in the best interest of this country that there should be some level of accountability from the judiciary. We all agree. They are human beings. They can make mistakes. They can be removed. I mean, ever since we enacted our Constitution 2010, we have had, if I remember correctly, we have had a Deputy Chief Justice removed through a tribunal because of some transgressions that she committed. We have had a judge of the High Court removed. On the other hand, we have had accusations that have gone to the level of a tribunal, and the tribunal has found that the allegations are unfounded, and the judge has been cleared to continue serving. My former teacher, Professor Justice retired Ojwang. He went through a tribunal and was found to not to have committed any ground warranting his removal. And that's how it should be, Mr. Speaker, that any level of accountability against judges should not be whimsical, but should be based on the law. And as we stand today, Senator Ochilo, under Article 168, any Kenyan can file a petition before the Judicial Service Commission and seek the removal of any judge of either the High Court or the Court of Appeal or the Supreme Court on account of any misconduct. And that's the accountability we are talking about. It's there in the Constitution. But what the Constitution says, judges should enjoy security of tenure, and for any Kenyan to want to remove them, there must be a basis, there must be grounds. But how do you have a situation where judges who every day are listening to cases, who every day are trying to enforce fair hearing in court, are themselves not subjected to fair hearing? It's a very untidy situation, Mr. Speaker. And therefore, as I get towards conclusion, I still want to make a very strong appeal to the President that this long-drawn fight with the judiciary is very unhealthy. And Senator Ochilo has put it very ably that there is some jurisprudence that we should be reluctant to see it coming up because we respect presidency. Mr. Speaker, it's an act of honor and privilege. It's an act of patriotism, even if it's for me. If I'm invited to go to State House to be sworn in as a judge, we want to see the president exercising that mandate because he's the president. But now, if we allow this matter to escalate all the way to the Supreme Court, and the Supreme Court makes a finding that his role can be ceremonial, and if he doesn't appoint, then the Chief Justice can swear those judges, I think we would have done a big watering down of the office of the president. So honorable is the office of a judge that in United States of America, one of the serving presidents, William Taft, served as a president, and when he left, Mr. Speaker, he was appointed a judge of the Supreme Court of America. That's how prestigious a position of a judge is. That's why when lawyers we appear before court, we address judges as my lords, because it's a prestigious position. And we want that prestige of our judges to be maintained, to remain intact. I wouldn't mind if after he has retired, and if he still has more years to serve the country, I see I see Senator Ochilo becoming Justice Ochilo. It will be an act of honor in his professional career. We had Lady Justice Njoki Ndung'u was a member of parliament. She was a nominated member of parliament, we all know. But now she has moved on, and she's serving this country as a judge of the Supreme Court. So you can move from this side to the other side. One of the best and most distinguished Chief Justices of the United States of America, Chief Justice John Marshall, who is the author of that power of judicial review for courts in the United States of America, used to serve as the Secretary of State for President John Adams. In fact, John Adams appointed him after his election, but before Thomas Jefferson had taken office. So he moved from being somebody in the executive to being the head of judiciary. But I can tell you, if you go to America today, one of the most respected chief justices to have ever served the United States of America, it is John Marshall. And he served many presidents. He didn't, in fact, he served during the tenure of John Adams for less than 2 months. Then John Adams left, and then Thomas Jefferson took over. And he served during the tenure of Thomas Jefferson. In fact, Mr. Speaker, when Thomas Jefferson was trying to remove Samuel Chase, he was testing the waters. He wanted to see if he had succeeded in removing Samuel Chase. He wanted to go after John Marshall, who was then serving as Chief Justice. But when the Senate applied brakes on President Thomas Jefferson, he abandoned the whole idea and served while John Marshall served as Chief Justice for the entire duration of his tenure. So with all these remarks, and as a true son of Kenya, a patriotic Kenyan, a lawyer, somebody who believes in the rule of law, we really want to make a very strong appeal to His Excellency, the President, to respect the Constitution as it is today, Article 166 and Article 172, and appoint these 5 industrious sons of Kenya and 1 daughter of this great country of Kenya to their respective positions of judge, judge of Court of Appeal, and judge of the High Court, so that we bring this matter to an end. At the end of it all, Mr. Speaker, this country will be the winner. The rule of law will be the winner. Our Constitution will be the winner. And we will all be happy as a country. With those remarks, I beg to reply, Mr. Speaker.
Thank you, Senator Omogeni. And Honorable Senators, pursuant to Standing Order 79-1, I determine that the motion before the Senate does not affect counties. I therefore proceed to put the question that the Senate adopts the report of Standing Committee on Justice, Legal Affairs, and Human Rights on a statement sought by Senator Mtula Kilonzo Jr. MP regarding delays in appointment of judges of the High Court and the Court of Appeal laid on the table of the Senate on Tuesday, 19th October 2021. Will as many as of their opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it. Okay, thank you, Senators. Order number 8 to 19 are deferred. Next order.
Order number 21, motion, fast-tracking cultural developments in counties.
Order number 21. The mover is not here, so it's deferred. Order number 22, 23, 24, and 25, and 26 are also deferred. Honorable Senators, there being no any other business, it is now time to adjourn the House. The Senate therefore stands adjourned until Tuesday, 16th November 2021 at 2:30 p.m.